Any mention?
Lordship, I beg to mention item number 3, Lordship, of the main list. Lordship, in view of the recent development, Lordship, and passing of the respondent CM, Lordship, of Sora, so we will have to apparently file a substitution application in the main writ petition. Therefore, Lordship, I am seeking indulgence to have the matter after 2 weeks. In the meantime, Lordship will prepare the application and have it filed.
The same
Respondent was sick.
has been impleted by name or by office.
He was by office. It was.
So
Represented by Lordship, represented by so and so.
that means the new same must be impleted.
Yes.
Has to be.
They have already recommended the name, waiting for the approval from District Council.
3 weeks
3 weeks, Lordship.
on pre-made by parties. This is matter of the 3 weeks.
Lordship, similar prayer for item number 9 of the main list, Lordship. This matter, Lordship, I am praying if it can be taken up next week, Lordship. This is with regards to the WAF board matter, Lordship, reconstitution of the WAF board. Learned Senior is leading in this matter, Lordship. I am praying if it can be taken next week, sometimes, subject to your Lordship's convenience.
Oh, this is that election matter.
My lord,
Election,
I have been elected as member of the work board. They are challenging my election, my selection.
Next week, Lordship, any date,
This
Lordship.
court has made it clear that no judgment will be.
Lordship, today, Lordship, some difficulty on the part of the Learned Senior, Lordship.
Who is the petitioner?
Lordship,
You are the petitioner.
Lordship. Any date, Lordship, next week, Lordship.
His term is running out.
Lordship, he is there in office, Lordship, otherwise.
But non-functional, my lord. Due to the pendency of this matter, government refuses to interact with us, saying that your constitution is under a cloud because of this proceeding. So we are practically non-functional, and number 2, my term will run out in about a few months' time.
We'll have it on Monday, Lordship. Then we'll have it as a fixed matter. Lordship can keep it.
Okay. Let's say this matter is decided
Lordship,
in Mr. General's client's favor,
Lordship.
and he'll have only hardly a week or two to.
This Lordship,
Then what happens?
Lordship. In fact, this plea what
Whole
my
exercise has to be,
Lordship, Lordship,
has to be started.
this plea what my Learned Senior is taking, Lordship. This was not there all around, Lordship. Today, Lordship, I think 1 month back only he has taken this very particular plea that he has not been able to.
The fact that hearing has not been conducted
It has
for the
been
last
2-3
1.5
years.
years.
Last 2-3 years, there was no objection with regard to that, Lordship. Suddenly, all of a sudden, he's coming with such.
Am I not allowed to object to the
Very,
repeated
very
time?
well, you are allowed, Lordship, but that should have come at the very first point of time.
That will be a matter of a hearing. 1 week.
1 week, 1 week.
No more.
No more
agenda.
adjournments, Lordship.
Mr. General and Council has sought for accommodation on the ground that the Learned Senior Counsel, Mr. K. Paul, who is leading the matter, is indisposed. On premiere, the same is allowed. It is made clear that the parties would make an endeavor for this matter to be heard expeditiously.
Hello.
I'll listen up to 1 week. 1 week.
Please, Lordship. I'd like to mention item number 4, Lordship. 2 weeks' time will be granted, Lordship, for hearing.
So 22 matter,
4, Lordship. This pension matter, Lordship, of GHDC staff. Pension matter.
pension matter.
Yes, Lordship.
Then,
This
where the
sometime
petitioner?
before the petitioner, Lordship. During penancy, Lordship, we've been receiving till March 2025 the amount. But some months is still pending. Just some time be given, Lordship, for hearing.
GHDC?
Yes, Lordship.
Who's appearing?
And for the state,
State has got nothing to do. You're the, you're all staff of the,
Yes, GHDC, Lordship.
if you have been receiving, you've been, see, this petition was filed in 2022.
Lordship.
And you said that you've been receiving the pensionary benefits or?
Pensionary benefits, Lordship. They've all retired.
Okay, so till March you have received.
Yes, Lordship.
Then
But it doesn't come at the right time, Lordship. It comes
that is a different thing. That is a different thing. That would not be subject to judicial review.
Lordship.
Those are administrative matters. Only if your pensionary benefit is stopped, then you have a cause of action. But if it is delayed for some reason or the other, I don't think you have a cause. At the most, we'll dispose of this matter with a direction to the authorities to ensure that regular pensionary benefits are given to you or pension is given to you.
Lordship.
So we'll do that.
Come up in 2 weeks, Lordship, because Mr. Shilla is leading this case.
1 week.
Thanks.
Mr. Learned Counsel for the petitioner has sought for accommodation on grounds of personal difficulty of the Learned Conducting Counsel, Mr. J. Shilla. On premium, it seems allowed. This is matter to 1 week.
May I please, Your Honor? I beg to mention item number 11 on behalf of the respondent number 2.
My lord, I am also the amendment. 11. Item number 11. Now, item number 11, kindly your lordship, this is a part-heard matter. Similar matter, lordship has referred to the Chief Justice, my lord, Honorable Chief Justice. And other matters has been sent back to Chief Justice in the past necessary order and placed before Justice. Thank you, Honorable Justice. Thank you. So this is also, my lord, a part-heard matter. So, my lord, similar order will come. Lordship will refer it to the...
You are for the petitioner?
I am for the respondent, Nehu.
Who's for the petitioner? You're for petitioner?
In other cases also same.
Yes.
Yes.
Because if again this court would would maintain that if the parties are agreeable for the matter to be taken up by this court, well and good. If not, it depends on the parties.
No, my lord, it depends on the orders.
Of course.
Hearing has been concluded. Lordship will kindly see. It's written hearing has been concluded by other court. Yes, concluded, my lord. This is the order detailed, Lordship. 10/7/25.
Okay.
Order civil listed, my lord.
Then Miss
It has to go back there. My lord.
matter will have to go back.
There is no uncertainty, your lordship. This should not have been, my lord. I don't know how the registry made a mistake.
Which court?
My lordship.
Which court?
Honorable Justice, thank you.
Okay. So we'll pass this orders.
Lordship.
Matter will go back.
All right.
Untuk order mga pass ko ini. I sim wording so. Ito ko ikis number ketika itu kis. Saya cek panu lini kiri.
My lord, seek your indulgence, my lord, for item number 8.
Lordship, I'm for the respondent.
My lord,
for written arguments. Lordship.
the hearing is over, fixed for written arguments. If Lordship allows me to kindly file it on Monday, I'll be highly obliged, ma'am. I'm on the verge of finishing it. Monday I can file it, ma'am. Monday or Tuesday, whatever's convenient.
You have filed yours.
Well, Lordship is ready. Lordship is ready since if my learned senior is seeking to file on Monday, then we might as well file on Monday together, Lordship. Or else it's already ready, Lordship, from our point.
But if you file your written argument, then you have to be slightly detailed.
No, absolutely. That is my intention.
By now, you see, I've
my lord,
what has been submitted.
My lord.
So at the most, you see, I have to depend on the written argument.
If necessary, we can refresh this honorable court also.
That the refreshing will take time. You do that 1 week's time.
My lord.
On pre-made by Mr. S. Jindal, let's wait after 1 week.
My lord. Obliged.
May it please your lordship. My lord, I beg to mention an unlisted matter, my lord. there is an urgency. It's a bail matter. The accused person has to appear his board exams, my lord, and therefore he have to even submit his assignment to the school, my lord. So, my lord, my lord,
Have you filed the application?
my lord, I filed the application this morning, just this morning itself, my lord.
Okay. Then it'll come up tomorrow.
Okay, my lord. Highly obliged, my lord.
Daily list item number 1.
Lordship, paper book is ready, Lordship.
What is this?
Paper book, Lordship.
This is for admission, isn't it?
This is the appeal against that.
Yes, this is listed for admission today. Or has it been admitted?
It has been admitted, Lordship.
Fixed for hearing?
Fixed for paper book.
Submitted on the earlier occasion that I'm also considering
okay.
maintainability of this appeal.
Once the appeal has been
Admitted,
that issue of maintainability will be heard along with the merits of the case. So this matter will be posted for hearing.
Lordship, I would like to start on the maintainability. We'll have to decide on that first. Because here is a case, Your Lordship, whereby they have come on appeal against a judgment of 2020. Thereafter, I filed my execution petition last year in the month of September. They have conceded before the execution court. They have suppressed some few orders which they have admitted to the capital amount. And they have submitted before the execution court that there is no appeal pending. Now they've taken a U-turn. And the law is very clear, Your Lordship, that once you have conceded before any court, you cannot take a U-turn and challenge, Your Lordship. And I want to place several decisions on that point also. And there's a suppression also, Your Lordship, whereby the orders whereby they have prayed before the execution court that they deposit the amount within 10 days. And that order has not been enclosed in the appeal. So on those grounds, I would like to, before we go into the merits of the case.
No, since the appeal has been admitted, now the stage is only for for preparation of paper book. That has been done. So what will happen is this matter will be posted for hearing, and on the date of hearing, the first issue to be considered is the issue of maintainability.
Lordship.
Be prepared on that.
Lordship.
Okay, now. Ms. Learned Counsel for the appellant has submitted that the paper book is ready and has been filed. You received copy?
I just received copies.
Mr. Pinobri, Learned Counsel for the respondent number.
One respondent.
Two, Your Lordship.
Who's one and who's two?
I am number 3, Lordship.
State is 1 and 2, Lordship.
Who knows wrong? I shall Miss Ailungwa Leonard G, appearing for respondent number 1 and 2, as well as Mr. Pinobri Leonard Counsel appearing for respondent 3 has also received copies of this set paper book today. Accordingly, this matter is now posted for hearing. Next. However, Mr. Pinobri Leonard Counsel has submitted that the issue of maintainability is raised at the outset, and as such, the said issue may be taken up for hearing as a preliminary issue. on consideration of the submission made, since the appeal in its entirety has been posted for hearing, the appeal will be heard on merits. However, the issue of maintainability will first be taken up by this court. Decision of which will invariably have a bearing on the further proceedings of this appeal. This is matter of the 2 weeks.
Obliged.
Item number 2.
None. Pass over.
Item number 6.
Six nggak pass over dari mana? Yang tu ada.
Your Lordship, Dr. Muzika is the leading counsel in this matter. Your Lordship, he's on legs before courtroom number 2. Your Lordship, I'm praying for some accommodation today, Your Lordship.
The plea made by Ms. Letter Counsel for the petitioner. List this matter up to 1 week.
Much obliged.
Item number 7.
My lord, this is that matter relating to VRS. My lord, this matter has been argued at length before my lords. So my lord, we will file our written submissions. This matter was already sent for...
refresh the report, Mr. Gautam.
Yes, Lordship.
Because in the meantime, matter has been
Yes, my lord. Yes,
sent
my
for
lord. Yes, yes. For some reason...
for settlement.
Yes, my lord.
Or whether it was sent for mediation.
Not for mediation. It was not sent for mediation. The matter was sent for...
Okay. But apparently no headway has been made.
No headway. Well, there were 2-3 sittings.
Having heard the matter, this honourable court was pleased to suggest for settlement between amongst all the parties, but it could not be fruitful. So we are back here, my lord. But it has been argued at length, lordship, before this honourable court.
The MEDC matter.
Yes, madam.
Okay. You are appearing for MEDC.
No, my lord. I'm appearing for the state. Mrs. Yangi is appearing.
Mrs. Yangi is appearing.
MIDC responded number 5 and 6, Your Honor. Your Lordship.
But she, okay.
I'm told she's on his legs in courtroom number 2.
So if my lord will permit, we'll file our written submissions, or
You can file your written submission.
yes, my lord.
But the matter will be posted. At least you refresh this court.
We'll do that.
As far as
It is required. I think
main facts
it's
are
more
concerned.
than 8 months that the matter was heard at length, Lordship.
All right, my lord. In the meantime, we'll file our written submissions, and our date may be fixed. We'll
That can be done, Lordship.
Letter counsel for the parties have submitted that the oral argument in this matter has been concluded. However, in the meantime, the matter has been referred for mutual settlement between the parties, which has eventually which was eventually not settled, and as such the hearing will proceed, will continue in this matter.
we have a mediation with somebody appointed from the court.
As prayed for,
The same like look at that.
let the written submission be filed within the next date fix. How long?
My lord.
How long? 1 week.
2 weeks, my lord.
2 weeks.
Usual course, Lordship.
This is matter of 2 weeks.
Much obliged, Lordship.
Item number 10.
Your Lordship, in this matter, notice was issued to the petitioner.
Then you service report. What is this case about?
Your Lordship, this pertains to the export of boulder stones, Your Lordship.
What's the case of the petitioner?
State respondents have issued an order restricting the number of drop supply from one quarry, Your Lordship. The petitioner, I agree by that order, Your Lordship.
Okay. But that order would be under section 144, isn't it?
No, Your Lordship. This is just to, Your Lordship, just to regulate the traffic flow.
From one quarry, only specific number of truck can come, Your Lordship. So they are agree by that order, Your Lordship. There are around 10 to 15 quarries, Your Lordship. So the state respondent has issued an order that from one quarry, specific number of trucks can come, Your Lordship, like 45 number or 50 numbers. So they agree by that order, Your Lordship.
Are you within your rights to do so?
Yes, Your Lordship.
Where is the impugn notification or order?
The impugn order is at page 36, Your Lordship, annexure 4.
I just want to point out here, Your Lordship, this impugn order, Your Lordship, have been issued against the quarry owner, Your Lordship. And the quarry owner, they are not before, Your Lordship. They are not agree with this order.
You are the owner.
No, Your Lordship. I'm one of the association, Your Lordship, registered associations.
Then why were you made a party here?
They're saying that we are collecting all this tools and all. There's the allegation of petition, Your Lordship.
But how can it, how can it be directed, in the same, order as the one assailed herein?
In fact, Lordship, if there's any person who's agreed by this order, it should be the quarry owner, Lordship, because it's their business which has been regulated.
And the petitioners are?
They are those some association, truck driver association.
Yes, Your Lordship.
We'll wait for the service report. If nothing comes, then we'll have to dismiss the matter.
Your Lordship.
By the order dated 23/10/2025, this court has referred to the office note dated 5/9/2025, wherein it has been noted that notice have been issued to the petitioners to engage a new counsel. However, no service report has been received in this regard till date. Accordingly, the registry is directed to issue fresh notice on the petitioners. The same returnable within 2 weeks. This is the matter thereafter.
Obliged, Your Lordship.
Item number 12.
Please, Lordship. This is the matter where the petitioner is the family member of the landowner on which the school has been set up, and she has been praying for regulation. She is in service in the school, and she prays for being appointed in the sanctioned post. That is the brief grievance, Lordship. If I may take your Lordship through the documents.
Is there any?
There is no registered deed, Lordship.
What is it?
No registered deed, but right after her appointment in 2017 also she was approved.
The land belongs. You said that the land belongs to you.
To my father.
Whatever the case may be.
Family member, yes.
And at the time when the land was handed over to the government, it was handed free of cost.
It was free of cost on an understanding.
So it's kind of a donation.
Lordship, yes, on an understanding that I will be appointed. In fact, what had happened is.
Where are there any documents to reflect?
There is an inquiry report which has brought that fact to the fore, Lordship. What has happened is, I was originally appointed in the school before it was upgraded by the government. I was already a in-service teacher, Lordship. Now when the SSA scheme came, they wanted to shift the school and make a construction. And that is when my father and my aunt had donated the land where the school is now standing. Thereafter, on the understanding that I will be appointed as a sanctioned teacher since I am already in service. Thereafter, Lordship, after the school was set up and everything, my name was forwarded and I was duly approved by the state authorities. But the school managing committee never acted upon it. Thereafter, inquiry was held. Again, it was found that in fact, my family member had donated the land, and as such, I should have been appointed in view of the fact that he is the family member of the landowner.
But have you approached the government in this regard?
Lordship, yes. Now, second time also approval has come.
What is the?
Lord,
they approve it.
Lord, my sorry to interject, my lord. Before my friend begins, my lord, I have some difficulty today. If this matter is taken up any other date, my lord. Even this week also I am okay, my lord.
Who's appearing for the managing committee?
He is for the managing.
Why are you refusing?
My lord is not. He is in the non-sanctioned post, Lordship. There are 3 posts in the school, Lordship. Now, what is saying that
question of non-sanctioned post will not come.
He is still in the
because
still in the yeah,
you see his her appointment has been made on the basis of an agreement between the government. Is it the government which has taken?
No.
The land was gifted to whom?
To the managing committee.
Managing committee.
In the sense that agreement was not
moreover, Lordship, her father has not donated the land. Now somebody XYZ has donated the land. Now, and he is claiming that my relative has donated the land, so I am entitled to get one of the sanction posts. Now there are 3 posts already there.
Whatever the case may be, you see, we have to go back to the initial agreement
Yes, yes.
between you and the
Yes.
petitioner's father or
Yes.
whoever is the owner of the land.
Yes.
So that has to be in place.
Yes.
Then from there we will come to know as to how the how the agreement was brought about.
Yes, yes.
If there was no objection to the title and ownership of the father of the petitioner at that point of time, now you cannot say that,
That is not in dispute.
it is somebody else's land.
If Lordship is pleased to see only one page, Lordship, page 58 of my writ petition.
In the
Annexure line, last page.
land donation deed, Lordship, there is no such condition that somebody from the family member in lieu of the land has to be appointed. The land was donated later. The school was taken over by the SSA prior to that donation of land.
Lordship will
She
only
has
see
appointed prior to the school was taking under the SSA scheme. Now the donation took place later and there was no such condition and donation was made by some other person. Now sometimes he is claiming that I should be given one of the sanction posts. There are 3 posts, and sometimes he is claiming that in the event if the government grant 4th teacher sanction, then I should be accommodated. Now 4th teachers are already in existence. Now the 4th teachers is not been made a party in this writ petition. Now one hand he is claiming that I should be within the 3 posts. Another hand he is saying that if the government in the event in near future grant 4th teacher, then I should be accommodated.
that is not correct, Lordship. If Lordship will only see page 58 of my writ petition, last annexure, Lordship.
Yes.
This is an approval order issued by the Joint Director of School Education and Literacy and District Project Coordinator SSA with a copy marked to the concerned authorities, Lordship. Approval order, Srimati Sujeta Das, SC 10+2, Assistant Teacher of Majipara SSA UP School is hereby approved by the undersigned based on the approval of the Subdivisional School of Education Officer Dadengre dated such and such and UDISE 2016-17 and being the candidate from the family of the landowner. Now they cannot dispute this position, Lordship. What I am praying is that my approval is already there since 2016 and reiterated in 2018. They are not acting upon it, Lordship. And as a result, my salary is also being affected, Lordship.
Okay, we'll take it up after 1 week. But I think this is clear, Mr. Sheikh. The order is very clear. If at all you have to, if at all there's a dispute, you have to challenge this order.
My lord, there are 4 orders apart from that order, Lordship.
4 orders.
Yes.
Subsequently.
Exactly. Yes, Lordship. Now, subsequent, there was an inquiry. My lord, that is why what I'm saying.
You file your counter.
Yeah, I have given all those documents.
You file your rejoinder.
Now he cannot claim within the 3. If the government wants to give.
No, here that or if what he says is correct, that order says that she is the 4th teacher.
But apart from that, there are other other approval order, Lordship, for the other teachers.
Then the government is answerable, Lordship. That how?
We'll take it up next. Obliged.
Obliged, Lordship.
On prayer made by Mr. Kipi Parchari Laneji seeking accommodation. On behalf of the state respondent, that is adjourned. This is him after 1 week.
Obliged.
Second call, item number 5.
Lordship, I'm praying 1 week time in this matter, Lordship.
What is this matter about?
Stepping up of the pay of the petitioner, Lordship.
On prayer made by Ms. Counsel of the petitioner, this is matter after 2 weeks.
Obliged, Lordship.
Any mention?
May I please, Your Lordship? Lordship, I beg to mention item number 13, Lordship. I'm praying for 3 weeks' time, Lordship.
Item number
13, Lordship.
why 3 weeks?
We are not yet ready, Your Lordship. We need some more time, Lordship.
On pre-made by the appellant, this is matter of the 3 weeks.
Obliged, Lordship. May I please, Lordship? I beg to mention item number 7 and 8.
This matter was already heard.
No, Your Lordship.
Not yet heard.
Not yet heard. I'm going to prefer 2 weeks' time, Your Lordship, in this matter. 2 weeks' time, Your Lordship.
On pre-made by the appellant, this is matter of the 2 weeks.
Obliged, Lordship.
Lordship, beg to mention item number 14, Lordship, on joint request. 14. 3 weeks.
On pre-made by the parties, this is matter of the 3 weeks.
May it please, Your Lordship, on the request of both the parties, Your Lordship, I would like to mention item number 9, Your Lordship.
This is for paper book.
Lordship, its paper book is filed, Lordship.
Then what is
for hearing now, Lordship?
You are not prepared.
Lordship, some difficulty from both these sides.
Pre-made by the parties, this is matter of the 2 weeks.
Obliged.
I'd like to mention item number 15, Lordship. This also on joint request.
Pre-made by the parties, this is matter of the 3 weeks.
On supplementary list, item number 1.
May I please, Lordship? Lordship, we have filed the paper books on Monday, Lordship. I'm praying
That will be posted for hearing.
Lordship.
Legal aid.
Private, Lordship.
Legal aid, private.
No, no, not legal aid, Lordship.
Miss Direct Counsel for the appellant has submitted that the paper book is ready and has been filed before this court. Accordingly, on pre-made, this is matter for hearing after 3 weeks.
Obliged,
My Lordship.
Item number 2.
You are ready with this matter?
My Lord, I am ready.
We'll take it up after the orders portion is finished.
Daily list, item number 1.
My please, Your Lord.
Your Lordship, we pray for some more time to file for paper book.
Mr. Direct Counsel.
Lordship, we have filed the paperwork. We have served an advance copy to the state. I may be allowed to, Lordship. In fact, we had tried to file it in the registry. They said that since the matter is today, if we can file it directly. Otherwise, I'll file it in the course of the day.
Lordship. It can be fixed on the same date, on 1st of December. My lord.
Okay. Mr. Legal aid or
no, private Lordship.
As the counsel for the appellant has submitted that the paperwork is ready and is filed today in court. Mr. S. Sengupta, additional PV, has submitted, appearing for the state respondent, has submitted that he has received copy of the same as paid for by the parties. This is matter for hearing after 3 weeks.
Lordship may have it on first because this is also connected to item 2, Lordship.
Yes. This is matter for hearing on first.
Much obliged.
Supplementary list, item number 2.
So, Mr. Chakraborty,
My lord.
your part is done.
My lord. My lord. My friend will reply as.
But I think your colleague the other day has yet to file the, yet to produce the authorities.
My lord.
He has not cited any authority. But,
Okay, well.
anyway, we'll allow that when you file your written argument.
My lord. My lord.
But even then, you have to give him advance.
Written submissions will.
Yes.
Authorities.
The authorities see, has to be given in advance to the respondent so that they can respond to it.
My lord.
Yes, Mr. Gung, how soon can you do it?
My lord, it will require some time, my lord.
Verse 130, we have that.
Exactly, exactly.
You can start for, then we'll see. Then we can continue on next date then. In that case. Please.
My lord. My lord, the genesis of the present case, my lord, arose by filing of FIR dated 16/11/1991. 16/11/1991. And my lord, the complaint was being filed by the brother of the victim, my lord, which is at page 1 and the type copy is at page 2.
Page 2.
My lord. If I may read, my lord.
Please.
I beg to inform you that on 16/11/1991 at around 4 p.m. at Lumkudung village, Sri Sadamuru, son of so-and-so of Lumkundung, has been murdered by 5 persons from Lumkundung village by the name of 5 accused person, my lord. Sri Tening Muru, Sri Luit Muru, Sri She Muru, number 4, Sri The Muru, and number 5, Kamai Muru. Therefore, I request you to kindly look and investigate into the matter and to arrest the 5 persons named above. The witness who witnessed at the time of the assault and the murder of Sadamuru, Sridal Rinklem, and father of Sadamuru have also been assaulted by this. This is the FIR, my lord. And my lord, this FIR has been exhibited, my lord, and exhibited as exhibit 1 by 1 FIR, my lord, by PW3. PW3.
Exhibited as exhibit 1 by 1.
1 by 1, my lord. Exhibit
1 by
1.
is-
Exhibit 1. 1 by 1
1
is
by
the
1 will
signature.
be the signature.
My lord? Yes. 1 by 1 will be the signature. So, this FIR has been exhibited, my lord, at the time of the evidence of PW3. Now, my lord, to prove the case, the prosecution had examined, my lord, 4 witnesses, my lord. Rest of the witness could not be examined, my lord, because during the trial,
Most of them have died.
Died, my lord. So, PW1 and PW3 are vital witnesses, my lord. They are eyewitnesses, my lord, to the incident. And PW4 is the doctor who conducted the postmortem, my lord. So, my lord, the evidence of PW1, 2 and 4 will be vital, my lord. I have to go through that, my lord. PW1 is at page 27, my lord. Type copy is at page 33. If I may read, my lord. I know all the accused person who are present in our court. Now, my lord, before I read this, my lord,
Yes.
I beg to bring to the kind notice of my lords that evidences were recorded after almost 3 decades, my lord. That will have a bearing on, my lord, the contention raised by my friend here. I know all the accused person who are present in the court today. One Sadamuru, who is now dead, was my younger brother, who died on 16/11/1991. He was murdered by all the above accused person. I saw the occurrence myself. The occurrence took place around 6:30 p.m. to 7 p.m. on the said date at the paddy field belonging to my mother, Ka Kyumuru, at Lumkudung. Immediately after the incident, I asked them as to why they killed my younger brother, who was not mentally sound. I further asked them why they did not inform me and my family before killing him, and to which they replied that they had already informed my family members, which in fact was not true. I do not know the reason why they killed my younger brother. Cross-examination, my lord. I was at my place of work from 13/11/1991 to 16/11/1991 at Sung Valley, where I make harvest of my paddy. I reached home on 16/11/1991 at about 6 p.m. The paddy of my mother is at Lumkudung village and met at Sung Valley. From Sung Valley, I reached my house first, then the paddy field of my mother. On reaching home, I took my meal. Then we did nothing to follow the accused along with our brother Usudamuru and asked them not to beat him. The distance of the paddy field from our home was about 100 meters. The time when they dragged him from our house is just before 7 p.m. During the dragging process, the accused person all manhandled my aunt brother,
My other brother.
my
Other brother should be.
it's written aunt brother.
Look at the original.
Other brother, Piamuru, my father also, Nihan shooting was assaulted by the accused. We did not inform the headman about the incident on the said date and time, but have however made the hue and cry to which none came to the rescue. It is a fact that my brother Usadamuru was left in the paddy field on 16/11/1991 till 18/11/1991. On being queried as to why she did not take her brother Usudamuru to her home immediately, she replied that a religious practice in Niamtre, it is not permissible to carry home case of a person who met with an unnatural death. It is a fact that my brother U Kiamuru reported the matter to the headman of Lumkudung on 18/11/1991, and thereafter a complaint was lodged with the police. I stated that the FIR lodged by my brother is wrong to the extent that I am an eyewitness. I do not know who attacked first the deceased. I was at a distance of about 3-4 meters from the place of occurrence. During this winter season on that particular night, it was still visible to the naked eyes, though the time was 6:30 to 7:30 p.m. at night. I was not at all examined by the police. The police examined only my mother, Ka Kemuru, and my sister, Ka Soli Muru, on 18/11/1991. Subsequently, I was examined by the police, and I have told them that the incident took place at 4 p.m. My statement before the police about the time is uneven, and my time before the court about the timing of the occurrence is correct. It is a fact that I never stated before the police that the accused person dragged my brother Usudamuru from our residence on the alleged date of occurrence. It is a fact also that I never stated before the police that my brother U Kiamuru and my father was assaulted and manhandled by the accused person. It is a fact that my deceased brother was a lunatic. It is a fact that my brother is hospitalized and is in mental jail, Shillong. It is a fact that my deceased brother was a criminal lunatic. It is a fact that only when he was provoked that he became violent. I do not know if my deceased brother destroyed the ripe paddy of the accused. It is not a fact that my brother was not dragged from the home on this date and time of occurrence. It is not a fact that my brother and the accused were already in the paddy field prior to the time of occurrence as stated by me. It is a fact that my deceased brother created trouble, and on time and occasion the Darbar Shillong directed us to hand over to the police, and thereafter they sent him to mental jail Shillong. I was not present on 18/11/1991 when the police came to inquire into the death of my brother. I do not remember at what time the police arrived at the paddy of my mother on 18/11/1991. I arrived at the paddy field of my mother at 8 p.m. on 18/11/1991. I was at home on 16/11/1991 at 6:30 p.m. I went to report the matter to police on 17/11/1991. My brother was taken to the hospital for postmortem. Now, my lord, the idea behind to read the entire evidence of PW1 is to, my lord, show that both from the examination in chief as well as the cross-examination, my lord, one thing remains unshaken, that is the presence of PW1 in the place of occurrence, my lord. Both in chief, it has come out that he was present at the place of occurrence at that relevant point of time. That could not be shaken, my lord, in the cross-examination. So it stands proved that PW1 was an eyewitness and was present at the place of occurrence at that relevant point of time, my lord. Now, furthermore, PW1 has revealed in his evidence that, my lord, the presence of PW3, my lord. Now, we'll go to evidence of PW3, my lord. It is at page 38, my lord. If I may read, my lord. I received summon to appear and depose before the court today. I know the instant case as the deceased victim Sri Sadamuru was my brother. I cannot remember the date, month and year of the incident. On the day of the incident, I was at home along with my parents and my deceased brother. At around 6 p.m., one Sri Dal Rinklem came to our house, and after some time he left our house. Thereafter, my victim brother went out of the house, and I saw 5 persons chasing my brother and caught him at the paddy field and started assaulting him. On seeing my brother being assaulted, I, along with my parents, rushed to the paddy field to stop those 5 people, but they still continue assaulting till he died on the spot. I know the 5 persons who have assaulted my brother, and their names are so and so, so and so, so and so. All the 5 has been named. Today, only accused Semuru, Themuru, and Tiningmuru are present in the court. All the accused persons are my cousin brothers. After assaulting my brother, all the accused persons fled away from the place of occurrence. I, along with my elder sister, young Muru went to Umulong Beat House to report the matter to the police, and the FIR was typed by someone whose name I cannot remember now, and I have signed the FIR. Exhibit 1 is the FIR, and Exhibit 1 by 1 is my signature. The dead body was guarded till the arrival of the police after 2 days of the incident. The police did some enquiry at the place of occurrence. I do not remember now if the doctor also came to the place of occurrence. Later, the dead body was handed over to us for conducting the last rites. Later, all the 5 accused persons were arrested by the police. It is a fact that I have informed the police about the incident at about 10 p.m. It is a fact that whatever I have deposed before the court today is true and correct, and the statement before the police that I was informed by somebody about the incident is not correct. It is a fact that me and my other 4 family members just stood at the place of occurrence requesting the accused not to assault the victim. But we did do nothing as we all are scared. It is a fact that only we, the family members, witnessed the incident at the place of occurrence, and none of the villagers saw it. At the place of occurrence, it was me, my father, mother, and 2 sisters, namely Longmuru and Dinamuru, were present. The dead body of the deceased victim was lying at the PO for 2 days from the date of incident. I saw that all the 5 accused persons together assaulted my victim brother. I had informed the police about the incident at Umulang. So, my lord, going through and reading conjointly, my lord, the evidence of PW1 and PW3, my lord, it remains established that the presence of PW1 and PW at the place of occurrence at that relevant point of time is proved, my lord. So, meaning thereby, my lord, that they being the eyewitness, they had witnessed the incident with their own eyes, and their presence is not shaken in the cross. It remains established. Now, so my lord, as to the first point, whether PW1 and PW3, being the eyewitnesses, were present at that relevant point of time at the place of occurrence, that is established, my lord. Now, also, we'll have to read the evidence of PW1, PW3, and PW4, the doctor who conducted the post-mortem, my lord, conjointly, in order to come to arrive at the, my lord, to make a conclusion that the deceased had suffered injuries, and these injuries, that the cause of his death was because of the injuries, my lord. That apart, my lord, evidence of PW1 and PW3 being the eyewitness, their presence and their witnessing the incident has been proved. That apart, they have also named, my lord, the accused person, 5 of the accused person by name, my lord. Now, the evidence of PW4, that is the doctor who conducted the postmortem, my lord. It is at page 40, my lord, if I may read. I received someone to appear and depose before this court today via VC, as I am not in good health and is not in a position to personally appear before the court. I joined service in the year 1980 and was posted at Umulong Dispensary. In the year 1991, I was posted at Joyce Civil Hospital. I received a requisition from the police to conduct the post-mortem on the dead body of Sri Sadamuru, male, aged 23 years, at the spot, place of occurrence, which is the paddy field of the deceased mother, Q Muru. Should be Queen Muru. The examination was conducted on 18/11/1991 at 2 p.m. Thorax, wall, ribs and cartilages healthy. Pleury healthy. Larynx and trachea, right lung, left lung healthy. Precardium healthy. Heart healthy. Vessels healthy. Muscle, bones and joint, injury nil. Disease or deformity nil. Fracture nil. Dislocation nil. External appearance condition of the subject normal. Wounds, position, size and character nil. Bruises, position, size and nature nil. Mark of the ligature on neck dissection, etc. nil. Abdomen, walls, peritoneum, mouth, pharynx and esophagus, stomach and its contents small intestine and its contents large intestine and its content liver, spleen, kidney, bladder, organ of generation, external and internal healthy. External appearance, scalp, skull, vertebrae. The head is broken. The head is broken, my lord. Membrano ruptured, brain and spinal cord extused. After examination of the dead body, I found the head is broken, the membrane ruptured, lacerated injury on the chin, and the chin is broken. Lower lips disfigured, incised wound on the left supratemporal region measuring 3 into 2 centimeters, upper jaw and 6 teeth broken. In my opinion, the cause of death was due to hemorrhage resulting from the above injuries. I have also prepared a report after the postmortem examination was observed. Exhibit 2 is the postmortem examination report and Exhibit 2/1 is my signature. Kindly see, my lord. The cross-examination was declined, my lord. So therefore, my lord, the evidence brought about by the PW4, my lord, is not disputed, my lord. So, and his opinion is that, my lord, that in my opinion, the cause of death was due to hemorrhage resulting from the above injuries. So, my lord, the second point, my lord, that is whether the victim had suffered injuries and whether he died consequent to those injuries, my lord, that has been proved and the defense declined to cross. So both the points, firstly, that presence and observation and of the incident by the eyewitnesses has been proved. Name of the accused persons have been proved, my lord, and injuries suffered that has been proved, and my lord, further that he died consequent to those injuries has been proved. Now the third vital question, my lord, is to whether, my lord, the accused person herein, my lord, had, my lord, dealt the blows, the injuries, my lord, with the intention and knowledge that he is going to, that the blow is going to be lethal and is going to die consequent to those acts, my lord. Now, after perusal of, my lord, evidence of PW1, PW3, kindly look at the nature in which he has been assaulted, my lord.
We will continue
next day, my lord.
next day or after break. Up to you.
We'll have it after a week, my lord.
Monday will be convenient.
Monday,
I believe your lordships are now going to sit on Monday and Wednesday. No?
Yes.
So we'll have it Wednesday.
Monday
Wednesday. Monday I have got all the matters.
Mr. Argurung Lenergy, appearing for the state respondent, has begun his argument but could not conclude the same. Hearing will continue on the next date fix. As prayed for, this is matter on 19 for further hearing.
Deeply obliged.
Daily list item number 5.
Rising.
See, Mr. Datta, we have a program with the bar.
Oh,
Now. So we don't know how soon
it will be reassembled.
No, we will sit as as and when it's over, but we don't know how long. The counsel for all the other.
Take a date. If your lord, my lord, if I can take a chance, otherwise there is no option but to take a date.
Lordship, I believe item 2 and 4 they are arose out of the same judgment. If this matter also can come on the set date, Your Lordship.
Mr. Datta is pressing for the matter, so we'll accommodate him. Can we take it up on Monday then?
No, in that case,
this court is sitting only on Monday.
Monday and Wednesday. That is an issue also. Well, in that case, let it go on 1st of December. Because next 2 weeks, my lord, I am little in difficulty elsewhere.
Otherwise, you would have liked to, start.
Well, I'll start on Monday if your lordship grants me that privilege.
Okay, so first.
We have no
Yes.
objection, my lord, if we start.
1st December.
1st of December.
Okay, then we'll ensure that Mr. Datta takes up his matter.
Yes.
Before the other two.
Yes, yes.
Katukai, as agreed to by the parties, list this matter for hearing on 1st December.
Lordship.
Much obliged.
Sorry for the inconvenience.
No, it's absolutely a pleasure coming over here. So,